Rominger, who's from Cumberland County, Pennsylvania, and Carl is going to assist us with the defense in Jerry's case. Probably most of you are surprised by what happened this morning. I don't want there to be any misunderstanding. We are not in any way conceding guilt. In fact, Jerry is more adamant than ever in his innocence and in expressing his innocence at trial. Today's decision was simply a tactical measure based upon an analysis of what was going to transpire. Most of you who have spoken with me over the course of the last 5 weeks realize that today's proceeding was only a preliminary hearing, a probable cause hearing. It was not a trial. We would not have been able to present any witnesses. We would not have been able to present a defense. In fact, we could not even have tested the credibility of the Commonwealth witnesses. All that would have happened today is that the Commonwealth would have had an opportunity to basically recite the allegations contained in the presentment that has been presented and filed against Jerry Sandusky in this matter, which really would have left us with the worst of all worlds. We would have heard a recitation of the allegations without realistically being able to cross-examine the witnesses who testified as to their credibility. And as all of you know, credibility is going to be the main factor in this case. Credibility is a situation that exists at trial. It's a measure which we can address at trial, but we could not have addressed today. And had we attempted to, I suspect we would have been foreclosed from doing so. One of the main reasons that we wanted to have a preliminary hearing and anticipated having one was because we wanted to be able to cross-examine Mike McQuarrie, who was involved in the allegations pertaining to accuser number 2. As most of you know, the credibility of Mike McQuarrie has been put into great question prior to today with various statements he allegedly has made, and we've verified the emails, but we still have not yet verified the comments allegedly made to Dr. Drainoff following whatever Mike McQuarrie said he saw in a shower room at Penn State University in March of 2002. Having done that and having realized that Mike McQuarrie's credibility was already a grave issue, we decided that when we looked at the strategy that we wish to apply in this case, that would make a lot more sense to waive this hearing and proceed with our defense, especially given the fact that we got a concession from the Commonwealth to address our pretrial discovery needs and requests in a reasonably fast way so that we can analyze that material more quickly and properly prepare for a trial. So again, having said that we anticipated nothing new coming out of this case by way of our defense and not being able to realistically present a defense or attack any witness's credibility today, we decided late last night that the better part of the tactical maneuver from our standpoint would be to waive today's proceeding, being very well prepared and realizing that we have much of the evidence we would have gained from today's proceeding without proceeding with it and putting everyone to the task of sitting in court for an entire day's worth of court hearings. Now, having said that, I'll be happy to answer any questions. Now, wait, I want to control this. I can't answer 5 or 10 questions. I'll take you first. Because we did not have meaningful discussions. We did not have meaningful discussions with the prosecution until yesterday afternoon. And even after we did so, that it was not certain that today's proceeding would be waived. And in response to that particular comment, you know, I always have to chuckle at attorneys who make comments about other attorneys' cases when they really don't know all the details. And I try not to do that. So I'm not going to comment on his comment, but I will say this. It was the Commonwealth who insisted that all the witnesses be here today because they were concerned that Jerry might change his mind and might want a hearing. So it wasn't us. As a matter of fact, I told the Commonwealth attorney last night he could call off his witnesses, and he chose not to do so, and I understand that because if Jerry had come into court today, even though we had agreed late last night to waive this hearing, then he would have been stuck with no witnesses. But that's the reason. We did not drag people into court. In fact, we tried to avoid that. And in fact, And in fact, we try to be sensitive to everyone. But unfortunately, because of the nature of the legal system, until a defendant actually signs the paperwork and waives his legal process, no one can assume that's going to happen, not even I. He could have come in, even though I thought he was going to waive, and at the last minute said, you know what, Joe, I've decided I want to hear it. So that's the reason why all those folks were available today. It had nothing to do with cowardice or gamesmanship. We would have called them off last night, but unfortunately, because of the process, the prosecution chose not to do that, and I understand that. Anybody else? I'll tell you, I'll take men, women, men. Yes. Well, what we discussed was if we were to waive the hearing based upon the realization that a probable cause hearing, which is what a preliminary hearing is a really low threshold of proof for the Commonwealth. All they have to do is establish the elements of the offenses, and the case is held for court on those charges. So realizing that, and realizing credibility was not going to be an issue, and in fact, the prosecutor, and I think correctly stated, that he would object to any questions I wanted to ask about credibility. And having given that information, we talked about if we waive the hearing, would they facilitate discovery, for example? Would they agree to maintain bail where it is, for example? Because I think most of you realize that a client who's not incarcerated is a heck of a lot more valuable to his attorneys in terms of preparing his defense than an attorney who's in jail. So we made those agreements, and based upon those agreements, we decided that we would waive the hearing today. We told them we would waive it this morning. They knew that last night.
I know you maintain your client for this. The lawyers for sort of victimizes people by having this geared up for this attempt and then cancel the last second. Any thoughts about that?
Well, there's a lot of thoughts about that. If in fact these young men were abused as children, then obviously there's a real issue as to whether or not they're being victimized by the process, not by us, but by the process. But on the other hand, ladies and gentlemen, if Jerry Sandusky is innocent, if he's innocent, which he has maintained, then maybe he's being victimized because he's going through this process. He's being followed day and night. He can't leave his house. Of course, now he's under house arrest. But media has been outside his home 24/7 for the last 5.5 weeks. So to answer your question, if in fact it turns out that these young men were victimized, were in fact victims, then certainly the process is causing them great hardship again. But that's the nature of the legal process. But on the other hand, Jerry has maintained his innocence, and as most of you know, in the legal process we have a great system that people who are charged with offenses are simply charged. They're not guilty, they're presumed to be innocent. And all we've asked from the media is to give Jerry Sandusky that opportunity to prove his innocence in a court of law. Today was a small part in this legal process. It was a part which would have been very one-sided, which would have been basically the Commonwealth's opportunity to represent all the allegations it's made without us having a chance to defend against them effectively. So based upon discussions with the prosecution and based upon their interest in providing us with discovery at an earlier time than maybe normally would be the case, we decided to waive today's proceeding. Yes?
What did the defense gain by waiving today?
We gained an assurance from the Commonwealth they'll give us discovery earlier than we normally would get it. We gained the assurance that the Commonwealth will not try to raise bail. And we also avoided the prospect of what all you folks would have done tonight. You would have reported the testimony today of the various Commonwealth witnesses. And all you would have heard would have been the Commonwealth's case, not our case, because today's not the time and place for us to present our defense. And I think, realistically, all that would have done is reaffirmed what many of you already think, that Jerry Sandusky is guilty and that he committed these offenses. And I thought that put him in a very unfair position, especially with all the coverage that there would have been concerning this hearing. So when we waited, and I'll be honest with you, this was a very close call. We really debated whether or not to waive this proceeding because we knew no matter which way we went, there'd be fallout. And obviously what you're telling us today is it's fallout from that perspective. But there were a lot of thought that went into this, a lot of considerations. But we felt at the end of the day that the better part of our case, knowing what we know, and we're very well prepared, but knowing what we know and knowing how this proceeding would go, that it was better to waive the hearing. I can think of 9 million right off the top of my head with Second Mile in terms of their assets. I can think of countless millions when I think of Penn State and the deep pockets. Do you realize that many of these young men already have civil attorneys for the lawsuits that are being filed, have been filed, or will be filed? What greater motivation, and I hate to say it, but it's going to be part of our case and we're checking on it now, what greater motivation could there be than money? I've seen money break up families. I've seen siblings become enemies fighting over their parents' assets after their parents pass away. So what greater motivation, folks, could there be than the financial gain that could come out of this by saying I'm a victim? Let me get somebody. I'll get back to you. No. Jerry has maintained it, and again, for those of you who just got into this case in early November when charges were filed, Jerry maintained his innocence in the first case involving accuser number 1 when it was a Children and Youth Services proceeding in Clinton County in 2008. That's when I first got involved in Jerry's case, when he came to me and said, Joe, I got a notice from CYS, Children and Youth Services, alleging that I abused this child. He said, I did not do it, I'm innocent, I want to defend against it. That allegation, which started off as a fondling case, grew into an all-out sexual contact case over several months, and it became evident to me that Jerry was going to be charged at some point criminally. From that point on, where Jerry maintained his innocence, he has maintained his innocence consistently. He has provided me with a wealth of information, which leads me to believe that he may well be innocent, certainly deserving of his day in court, at trial, not a preliminary hearing, which is not a trial, but at trial to establish his innocence. He remains totally prepared and committed to proving his innocence, and in fact, we're proceeding on that premise, and that's why we have additional counsel, and we anticipate there'll be some other volunteers, which is interesting also, folks, because over the last 5 weeks, what started as no one believing Jerry Sandusky, we now have people actually calling us, offering to help, saying, you know what? You've made some good points, and now we're starting to wonder about whether or not these acts actually occurred. And we're going to continue with that premise. We're going to continue to develop Jerry's defense, and we anticipate a trial later in 2012. Let me get some people over here. If I understand, because I had a little trouble hearing you, if I understand you correctly, why is Mike McQuarrie's credibility such a big factor? And the answer is, Mike McQuarrie was the centerpiece of this prosecution. Everywhere I went, every time I heard someone speak, they would say to me, well, we can understand how he said, how somebody now, a young man, said Jerry Sandusky abused him. But why would Mike McQuarrie say that? Why would Mike McQuarrie say, an assistant coach at Penn State, a former quarterback under Sandusky, while Sandusky was here at Penn State as a coach? So Mike McQuarrie wouldn't make up a story. Well, the fact remains, folks, you're all reasonable people, you're all intelligent. Think about this factual pattern. If you believe that Mike McQuarrie went into the shower room at Penn State on a Friday night in March of 2002, saw Jerry Sandusky anally assaulting a 10-year-old looking boy, walked out of there without offering to help that child, without offering to call the police on his cell phone, and by the way, Penn State police were 30 seconds away from that building, went home and talked to his dad, who didn't tell him to call the police, simply went to Joe Paterno the next day and said he saw what he saw. Joe Paterno then went to Tim Curley and told Tim Curley whatever he told Tim Curley, and Tim Curley's response, if you believe Mike McQuarrie, when Mike McQuarrie says he told Tim Curley he saw Jerry Sandusky engaging in anal sex with a 10-year-old looking child in the shower room, Tim Curley's reaction was,